views and opinions expressed in this program are those of the participants and do not necessarily reflect the views of BronxNet or the program underwriters.
All right, coming up on this edition of Today's Verdict, after a long, exciting, and stressful 9 months of pregnancy, the last thing you'd like to hear is that your baby has experienced a birth injury. On today's show, we will learn all about birth injuries and what you can do to prevent them. Next, we jump right into the area of estate practice as we tell you everything you need to know about preparing a will. And finally, it's a situation that happens all too often. Those who are accused of a crime but waiting months and sometimes years for a trial, all the time waiting in a local prison. As you can see, we have much to get to, so stay tuned. Today's Verdict starts right now. All right, hello and welcome to Today's Verdict, the live and interactive show that gives you your legal rights and options. I'm your host and trial attorney, David Lesh. Well, Today's Verdict is always encouraging you to stay connected. Make sure to tweet us at Today's Verdict and hashtag Ask Today's Verdict if you have a question. Also, make sure to like us and follow us on Facebook at Today's Verdict and check us out at bronxnet.tv/BronxLegal. And last but certainly not least, don't forget to tweet me at David Lesh. A birth injury is considered the result of an unavoidable birth defect. But what if the injury was avoidable? What if the doctor or nurse on staff committed malpractice? We now learn all about birth injuries and your remedies with attorney Jordan Merson. Hi, Jordan.
Hi, David.
Thanks for being here.
Thanks for having me.
All right, let's start a little bit from the beginning. What's the difference between a birth injury and a birth defect?
Okay. A birth injury is something that occurs in or around the time of birth that causes injury to the baby. A birth defect is more congenital in nature, meaning it's something from the DNA or something that is a baby is going to be born with, and it's sort of unavoidable.
Maybe like a cystic fibrosis or
something like that.
That would be considered to be something that genetically you're predisposition for, correct?
Exactly.
Okay.
But just because there is a birth defect does not mean that there is not medical malpractice.
Give me an example.
An example would be, I've had a case where a little girl was born with what's known as tetralogy of Fallot. What that means is that the baby has a number of holes in the heart that are normally, they close up. In this particular baby's case, it did not close up. So the baby was born and the baby had trouble getting oxygen to the hands, to the feet, trouble breathing. And there was a delay in the doctor actually diagnosing the birth defect, which led to an injury.
I understand. All right, now, what types of malpractice situations do you find occur the most during the birthing process? Is it lack of oxygen? Is it, it used to be, using the forceps in an improper way? What do you see in your office seems to be the most avoidable type of birthing injury?
Yeah, well, as you correctly stated, forceps injury is less common, although not completely avoided now. There are still forceps injuries, but the most common is what we call a hypoxic birth injury, which means a lack of oxygen to the baby's brain during the birthing process, which causes some sort of damage to the end organs, the brain, the intestines, or anywhere else in the body.
That cannot be reversed.
That cannot be reversed. There are treatments when the baby is born with brain damage that can be done, such as cool cap therapy, where the baby is literally forced in a hypothermia. The baby's body is cooled down so that the brain damage does not spread and get worse.
Now, listen, my wife, she had a cesarean section. Are the doctors supposed to be monitoring right up to the very, very end to see if, well, I know she wants a natural birth, but this has to go a different way because the baby's not getting enough oxygen? Are there different things that the doctors or the nurses should be looking at?
Yes, absolutely. What happens when you go into the hospital, what's supposed to happen when you go into the hospital to deliver your baby, is they're supposed to put on you what's known as a fetal heart monitor. And they put a belt around the mother's abdomen, and they are able to see second by second what the baby's heartbeat is doing and what the mommy's heartbeat is doing. And when they see that the baby's heart rate, the typical fetal heart rate is somewhere between 160 or 120 and 160 beats per minute. An adult is 60 to 100, but for a fetus, it's between 120 and 160. And if the fetal heart rate continuously goes below that amount, that is an indication that there is some issue with getting oxygen to the baby's body.
Now, does the patient, mother, or when you think about it, it's also the father as well, when do they first learn, or when do they realize that whatever has happened to their child has been the result of malpractice in the birthing process?
Well, that's one of the problems. Sometimes they never know. Many times people have come to my office and their baby is, and we can get into the statute of limitations in a little bit, but their baby is 12 or 13 years old, and somebody makes the connection for them. But they are literally unaware that their baby has had some sort of birth injury.
And they just think that this was just because of a genetic defect or some type of issue.
Exactly.
And they don't know.
They don't know.
Now, what is the statute of limitations? How much time do you have to bring an action on behalf of your child?
Well, as with most things in the law, it's unfortunately not an easy, clear response. But generally, it is 2.5 years, 2 years and 6 months for any claims that the parents may have. The baby's been injured, the parents will also have claims. For the baby, it is 10 years from the date of birth. However, there's a star or an asterisk. If you are born in a city or a state hospital, and this is very, very important because there's a few city hospitals in and around the Bronx and Manhattan, you have to file what's called a notice of claim within 90 days.
And that's 90 days of the actual malpractice.
Exactly, not from the time that you realize it.
Right, so some people might think, well, I found out about it 6 months later. That's not good enough. You have to do it within 90 days of the time you actually give birth, or assuming that's when the malpractice was.
Yes, exactly. You have 90 days, and there is a way within a year and 90 days that you can make a motion to ask for the court to forgive you for not filing within that 90 days, but the safest bet is
get to you quickly.
Immediately.
Okay,
yes.
Now by the way, where do we find you?
Well, you can find me on the internet, as with most people. If you Google Jordan Merson, you can also go to my website, mersonlaw.com.
Are there particular hospitals that you seem to see as more often involved in some of the lawsuits you have? Not to put a black mark on, say, Lincoln Hospital or Bronx Municipal, but do you see certain areas in the Bronx that sometimes tend to show up in some of the complaints?
Yeah, I would say in the Bronx it's pretty evenly distributed.
It
we have cases against every major hospital, I would say, in the metropolitan area, or in the New York, in the 5 boroughs. So, it unfortunately happens everywhere. And the best advice to give someone is if you suspect that something has gone wrong during the labor and delivery process, do not wait.
Any final tips you can give to somebody before something goes wrong in terms of the birthing process, something they should be looking out for to make sure that they don't necessarily have to see you?
Yeah, make sure you're getting the care that you deserve. There are people who sit back and they think that the doctors or the nurses are always doing the right thing, or they're afraid to bother the doctors or the nurses. If you feel that you are being ignored or neglected,
speak up.
Speak up, and speak up immediately. And the same is true from a legal perspective. If you think that something was done wrong during the birthing process, don't wait. Call a lawyer and know for sure whether or not something was done wrong.
Well, Jordan, great advice. We really appreciate you being
Thank you
here.
for having me.
All right, well, we have to take a quick break, but don't worry. We'll be back with more Today's Verdict right after this. All right, well, welcome back to today's verdict. I'm your host, David Lesh. We are always encouraging you to stay connected. Tweet us at today's verdict. After the loss of a family member or friend, a will can make the transition a little easier, but so many of us do not take the time to create a will. Today we'll discuss different ways to make the estate planning easier for you and your loved ones with attorney Jules Haas. Jules, thanks for being here.
Very, very well, David.
Well,
thank you very much for having me.
It's my pleasure. Why is it so hard to get those who are older than you and in the later stages of life to commit to either doing a will or doing some type of estate planning? What's the fear?
Well, I don't know if it's so much fear, David, and it's also not people that are older, but younger as well, because everyone really needs a will. I think it's a matter of having to put in the time and the thought and the effort to doing a will.
And is it the family members, do they push dad or push mom, or even for themselves? What gets somebody motivated to finally say, you know what, let me do a will, let me maybe create a couple of trusts? What can push people? Hopefully watching you will push somebody to do something like this.
Well, in my experience, there are a few things that push people to do a will. Number one, having children.
Right.
A lot of my clients come in and say, we just had children, we want to do a will because we want to make sure that what we have goes properly if something happens to us. That's number one. Number two, for people that are older, they sort of have events in their lives that sort of make them think about the consequence of what they need to do to distribute their assets in the event something happens to them.
I will tell you, personally, my wife and I basically said, we're not traveling, after we had our child, until we actually do wills. So we know who, God forbid, if something happened to us, who might be, our child's guardian and so forth. So you're right, sometimes an event or something happens. So if somebody comes to you and they're ready to do a will, what's the first thing that you're looking for in terms of acquiring information? What do you need from them?
Okay, so the first thing I would talk to an individual or a couple about is to have them understand what their assets are and how those assets are owned. Because a will is only going to control assets that are in your name alone. So for most people, particularly married couples, their assets are going to be held jointly. A will is not going to control those assets. A will is not going to control assets where there are designated beneficiaries, such as pensions, IRAs.
Right, and these things would necessarily, as we say, pass outside of the estate.
That is correct. They would
Okay.
pass outside of your probate estate
Okay.
by what we call operation of law.
Sure.
So what you do not want to happen is to plan your estate and write a will and say, I leave everything to so-and-so, and as it turns out, you have all of your assets titled, so to speak, with someone else.
And that could be a bank account, or that could be your home or something else, right? It's in joint ownership, so you don't necessarily own the whole thing. And when you die, it goes right to the other side or to the other person, and not necessarily to your heirs, right?
Right. And most often, the problem arises with things where you put designated beneficiaries, such as IRAs, pension plans, life insurance policies. I can't tell you how many times couples come in and I say, who's the designated beneficiary on your IRA?
And they don't know.
Or they sit there and they say, I think it's my parents, because they never went back and changed it or thought about it after they got married. So the process when I begin is to make people start to think about what they're doing.
Now, do you also talk to them about end-of-life care, how they would like to be treated, when it comes right down to it, towards the very end, whether or not they want feeding tubes, whether they want do not resuscitate orders, or these things are also discussed?
These are discussed, but it has to be a certain situation. In most instances, when people are coming to me to do a will, they're looking to do a will to plan, let's say, for their children, whatever. They're really not thinking about or concerned with an end-of-life situation, which of course we can discuss because there are things that you need to do for that as well, where you can do powers of attorney, you can do not resuscitate orders. For every person that I do a will for, we do a healthcare proxy.
You do. And
That's
what is a
standard.
healthcare proxy?
A healthcare proxy is provided for by statute. It's basically a power of attorney to make healthcare decisions. So if you're unable to make a healthcare decision for yourself, then you designate who's going to make that healthcare decision for you. So it's very basic, it's very simple, and it's provided for by New York statute.
Now, who carries out all the functions with respect to the will? Because obviously you're not around anymore, so who's going to do this and make sure that everything is taken care of?
So the person that's going to take care of your will is your executor, all right? They're the person who will execute your will and carry out your intentions. So when you do a will, you're going to designate, you're going to name the person that's going to act as your executor.
And should you know who this is before they come and see you, or should you just come and see you and then talk about who you might recommend would be the best to carry out the duties, or both?
Okay, well, when I speak to clients, I tell them to think about these things. Very often when we sit and talk, that's when they start to think about it. I personally will never recommend to anyone. I will discuss the pros and cons of certain individuals if they ask me, but picking your executor is a very personal thing. It's someone that you need to have trust in. It's someone that you believe will carry out your intentions when you're no longer around.
What types of problems do you see that develop in the whole will creation process? What's the biggest issue that ends up having to be resolved? Is it, deciding what children are going to get what, or creating trusts for grandchildren, or what do you see leads to the most amount of work for you on a situation involving a will?
Well, I think that the most difficult problem that folks need to resolve is who actually is going to carry out their intentions. Many times picking an executor is not easy. Most of the time folks come in, they have pretty set ideas as to whom they want to benefit from their estate. There are instances where there may be questions that they have, but most of the time people know. And in most situations, people have close family, they have close friends, they have people that they really care for. And so picking those people it's not a difficult task.
Yep.
One thing though that is difficult, or that may be difficult, is that when I say, who's going to take your property if that first person's not around? Who's going to be your alternate?
Alternate.
Because they don't think in those levels.
Which happens.
Which happens very often.
Okay. Where do we find you, by the way?
Okay. The easiest way to find me is you could go to Google and type in my name, Jules Haas. You'll see my website, you'll see my blog, New York Probate Lawyer. You'll see loads of information in my website about wills and trusts and all of the information you need.
Any final tips about wills? Something you want to make sure everyone who's watching right now knows or should know?
Yes, the most important thing is to do a will.
Do it.
Because if you don't do it, your estate's going to be distributed according to the laws of intestacy, which is under the New York statutes, and your assets are going to go to people that either you don't know who are members of your family, or that you certainly don't want to receive them.
Good advice, Jules. Thank you very much.
Very good. You're very welcome.
All right, we have to take a quick break, but don't worry, we'll be back with more of today's verdict right after this.
We are neighbors and best friends.
I love my sister.
My heart doesn't see race. Love is love.
Our family is no less than any other family.
All right, welcome back to today's verdict. A civil rights attorney filed a complaint in Southern District of New York. His client was ordered released from Rikers Island on November 28, 2014, but was not released until April 15, 2015. Here to tell us more is attorney Welton Wisham. Welton, this is serious.
Absolutely.
Tell us what happened here.
On November 21st of 2014, my client, Adadella Salam, was arrested for stealing a coat out of a store in Fifth Avenue, Lower Fifth Avenue, New York City. He was also charged with assaulting a police officer. This officer was undercover, and he had no idea that this officer was a police officer. And allegedly, the police officer was injured as a result of my clients trying to get away. Now, I did not represent Mr. Salam on the criminal matter. He was charged with assault in the second degree, which is a serious felony. He was arraigned the next day of November the 22nd, 2014. During that arraignment, he appeared. He had two other companion cases. One was a felony and one, I believe, was a misdemeanor. On the misdemeanor, he was sentenced to time served. That left him with two other felonies. On the felony that he was arraigned for, it was adjourned to November the 26th. Both cases were adjourned to November the 26th. On November the 26th of 2014, Adel Salam was not present in court. He was not produced. The judge at that time reduced the bail. Well, I should say on November the 21st, the bail was set for the two felonies of $25,000 each. Mr. Salam had bail of $50,000. On November the 26th, one of the cases, the bail was reduced from $25,000 to $1.
Okay.
Adel Salam was not aware of the fact. No one informed him.
Now, how does that happen? How does somebody not realize that your bail has been reduced to $1 so you could just basically walk out of jail?
Well, he couldn't have walked out of jail at that point had he paid the $1 bail because he still had the
other one. Okay,
he still had the other felony.
But he still should have been told that one of the possible crimes against him in terms of the bail had been reduced down to $1.
Absolutely. This is basic fundamental fairness.
Sure.
2 days later, on the 26th of November, the judge put the case over to November the 28th because it had 144 days because it's a felony. The district attorney has to bring an indictment within 140 days if he's incarcerated, which he was. On November the 28th, the district attorney failed to bring the indictment. They failed to bring what's called a true bill. At that particular point, under the criminal procedure law, the judge has no other choice but to order him released.
Correct.
And the judge ordered him released, not any bail, ordered him released.
Now, when he issues this order, is it on the bench? Is it through some type of written order? How does the parties get? How are the parties made to know that the judge is now ordering somebody released?
It's both. It was a transcript, so certainly it was on the bench. And
Okay.
again, Mr. Salam was not present for whatever reason. The legal aid's attorney waived his appearance. The judge and the district attorney agreed to have him released. An order was submitted to the Department of Corrections at Rikers Island, where he was housed at the Annam Cross Center. Someone knew, they had to have known, that Mr. Salam was ordered released from incarceration on November the 28th, 2014. He was not released for another 138 days. He stayed incarcerated at Rikers Island until April the 15th of 2015.
Now, how does that happen? Where is the breakdown? Is it that the courthouse isn't getting or the district attorney isn't getting the order to the officers at Rikers Island? Where does that happen? Where's the break in the chain?
The break in the chain, we believe, is at the Department of Corrections. They certainly have procedures to produce inmates. They have procedures to process court orders. They can't deny that they did not receive the court order because I got a copy through the Freedom of Information Act, and it's part of the complaint as an exhibit. They were aware that the court, Melissa Crane, the Honorable Justice Melissa Crane, ordered Mr. Salam immediately released from incarceration, and they failed to process him for whatever reason. We don't know. That's why we filed the lawsuit, but we will certainly.
And what are you claiming in the lawsuit specifically? What are some of your allegations?
We're
there?
claiming that under the 14th Amendment, every individual has a right to be free from wrongful incarceration. This is a basic core right of liberty, which was violated. His 14th Amendment right was violated because they failed to release him on a timely basis. There was no justification for this individual to still be held in Rikers Island. We took an extensive amount of time to search the records to see if there were any prior holds, if there were any outstanding warrants. none of
Nothing's
which was
there.
present. There was nothing there. Someone, according to the records, paid his $1 bail on April the 15th, and he was released. He walked out.
So what's next? You've started the lawsuit. Has there been an answer? Is there any discovery that's been done yet? Where are we in terms of the lawsuit?
The lawsuit was filed June the 26th of this year. And the next appointment for court would be October the 10th. There has been no answer because we had agreed to wait until the October the 2nd to receive an answer from the Legal Aid Society as well as from the City of New York regarding this matter.
Where is this heading? What do you think? I mean, is it you're obviously asking for some monetary amount. Is it a case that you think might be tried? Where are we going?
And also the good question, when I finished law school several years ago, I thought that when there was a wrong, that people would just apologize and ask you how much you want and just give you a check.
Hey, wouldn't you think that would be?
It doesn't work that way.
No, it doesn't.
I'm looking forward to litigation. If it goes to trial, we look forward to that date.
Have you heard of other situations where this has happened? Or does this seem like a unique situation?
I spent over a year doing research before filing this lawsuit. The failure to release inmates upon court order, it's endemic in a lot of different criminal justice systems throughout the country. There's been lawsuits filed in Los Angeles County in the 1990s where they settled the lawsuit for about $27 million because thousands of inmates were detained beyond their court order release dates, or it would take them 3 or 4 days or weeks to process bail. In Washington, D.C. recently, same situation where individuals are held, judge orders and released, and it should only take a couple of hours. What winds up taking 2 hours takes about 7 days or 10 days to be released. So this is systemic.
I'd like you to come back maybe in the next 6 months and let us know how the case is going and give us an update, and hopefully things will go better.
I would love to, sir.
All right. Well, that's all the time we have for today. I'd like to thank our guests for joining us, and of course you, the viewers, for watching. If you missed any part of today's show, be sure to check it out at www.bronxnet.tv. Also remember, if there is a legal issue or topic you'd like to see on a future edition of Today's Verdict, feel free to contact me at davidlesh@bronxnet.org or tweet us at Today's Verdict, and make sure to hashtag #AskToday'sVerdict. For myself and all of us at Today's Verdict, always remember, know your rights, know your issues, reach your verdict. We'll see you next time.
How can I help my daughter with her reading?
Searching for help with Dachshund Reading.
No.
Let me try. Sarah's bright, but when she's reading, she has trouble sounding out words.
Playing world music.
What?
I give up.
Wait, I